Good morning, everyone. We are happy to be here to celebrate the great works of the Children's Rights Litigation Committee over the last 20 years. And what a great start with some of our co-chairs who shared with you some of the great works that we've done over the course of that 20-year span. But also, too, with the question that was left, where are we today and where are we going? So without further ado, I'm going to go ahead on and introduce our esteemed panelists. And we're going to defer to each to share a little bit about who you are, what is your affiliation, and also information around the work that you do. So we'll start off with Martine Gautu.
Great, thank you.
Okay.
Working? All right, there we go. Thank you, Francesca. My name is Martine Gauto, and I'm a senior attorney with Catholic Legal Immigration Network. Our acronym is CLINIC. We're based in Washington, D.C., but I work out of Los Angeles. Been with them for about 4 years now. And I'm here to provide a little bit of a background and angle on immigration. Should I give my entire 5-minute spiel now? Okay.
Yes, please.
Okay,
Thank
great.
you.
And then I'll pass it on to my colleagues. So I don't think there's that many immigration-focused attorneys in the room. Can you raise your hand? I know there's at least one other one. All right, there's 2 of us. Awesome. So hopefully the rest of you will learn some things today. I'm sure that you're at least aware of the immigration context because you're passionate about kids' rights and you probably know about some of the bad things that are happening. Long story short, it's a dark time for immigrant children, and it's hard times for lawyers representing immigrant children. I wake up every day with a little bit of nervousness, not knowing what the day is going to bring as far as headlines, attempts from the current administration to strip children of rights, make things more difficult. There is no right to government-funded counsel in immigration court proceedings for children. I guess that's what I want to start with. You can have a lawyer if you can pay for one, or if you're lucky enough to get a pro bono attorney or a legal service provider to step in and take your case. But even that right is not absolute, because I've seen situations where immigration judges have said, all right, you're at this first hearing without a lawyer, show up in a month with a lawyer, or we're going to proceed with your case whether you have one or not. So even then, it's not an absolute right. You're given a very limited chance to try to get a lawyer even when you're a child. The Ninth Circuit recently even said in a published decision that there is no right to government-funded counsel for children in immigration court, and that was a brutal loss. Our friends at the ACLU really took that case to court and along with their partners, and that was a really brutal loss and hard to see that because really deportation for many of our clients is akin to a death sentence. So when you say that you don't have a right to a lawyer in a case that could be a death sentence is really just disturbing and should not be happening in the United States in 2018. Most of our clients these days are coming from Honduras, El Salvador, and Guatemala, which are 3 of the 5 most dangerous countries in the world. There's a lot of insecurity, a lot of gangs that are terrorizing families and children. For example, the gangs will force a family to pay quote-unquote rent, and if you don't pay us $100 a month or whatever it is, we're going to kill all your children. Or they'll find the young lady in the family and say, she's basically going to be our girlfriend, or else we're going to kill her, or others from your family. The young boys, they say, you're going to join the gang or you're going to die. So these are really serious consequences, and these children are coming here for protection, they're coming here for asylum, and they're not often getting the chance to really bring those claims forward with representation as would be appropriate. A child without an attorney in immigration court has maybe a little bit better than 0% chance of winning their case. I've heard it said that immigration law is second in complexity only to the tax code. I don't know, new changes that well, maybe we're first, I don't really know. But suffice it to say, it's ridiculous that a child should be expected to argue their case against a trained government prosecutor in immigration court. It's just ridiculous. How many of you are familiar with the comedian John Oliver? Did anyone see the piece he did a couple weeks ago on this issue? So for those of you who haven't seen that, I could talk about this. I'm not as funny as John Oliver. I'm not as exciting. Spend 15 minutes watching that piece and others that he's done, obviously, and you will learn probably more about this issue than I could teach you in the few minutes that I'm up here, because he really highlights and underscores the absurdity of this notion that children ought to be representing themselves in court. He does a mock trial at the end with a series of 3- and 4-year-olds playing the role of the judge and the prosecutor and everybody, and it really highlights and underscores how ridiculous this whole notion is and how sad it is and appalling. So there are some positives. Like I said, it's dark days. There are things that are happening that should not be happening. It was mentioned earlier, children are being separated from their parents at the border. A litigation issue, since this is the litigation committee's section that is sponsoring this event. Children are being removed from their parents at the border. Parents are being held in one detention center. Children moved to another detention center, but yet the children are not getting the right to litigate their claims separately. Children are being included on the cases of their parents, even though they're separated. So children is getting effectively zero chance to even bring a claim forward as being attached to their parents' case. Children are languishing in detention for longer periods of time because the current administration is targeting the potential sponsors of those children. So long story short, the immigration detention system for children is supposed to be a family reunification program. Child gets arrested at the border, they're immediately supposed to have someone looking for a family member or responsible adult to whom they can be released while they fight their immigration case. But when the government is targeting for deportation and immigration enforcement, those potential sponsors, they're afraid to come forward, which means children languish in detention even longer. Many of them lose hope and opt to take a deportation order instead of staying and trying to fight their case, even if they have a strong case. So I said there were positives, but I didn't give any positives. There are some positives. It was up on the screen, and that great list of important cases, the Flores settlement from 1997, which is still actively being reviewed and monitored by the great attorneys who fought that case. Attorneys such as myself are fortunate to be able to go in to detention centers for immigrant children because of the Flores settlement. Children are getting at the very least, know your rights presentations when they're in the detention centers so they can try to understand and make sense of what's happening to them while they're here. They have access to a legal screening from an attorney from a legal services corporation, or excuse me, a legal services provider. They might not necessarily lead to representation depending on the resources of that organization, but at very least they have someone sitting down with a human face and a heart who's listening to them, listening to their concerns, and can potentially make a referral for representation. So those are the positives. There is more funding right now for legal representation for children than there's ever been. There's still not enough, but there's more funding and we need more. So those are some of the positives. And I'm going to talk a little bit later about some of the things that attorneys are doing in the current climate that I tried to describe to you about how to react to the current administration and make sure that we continue fighting for kids' rights every day. So I'll pass it on.
Thank you, Martine. We will have Michael Tiger, Emeritus Professor, Duke Law School.
Does this work? No, it doesn't. We'll use one that works.
Which mics?
My name was up there at the beginning. I'm sort of a lawn ornament for this. A memory of statue. You pass by and say, oh yeah, I remember him. That was when we started out some of these things. I wanted to talk today about juvenile injustice as we see it in the courtrooms, because that's the place where I have lived most of my professional life, and that's the place where young lawyers now who just coming out of law school and getting into this work need to have an approach to the skills that they're going to use, because we see a landscape of juvenile injustice that's just littered with the shards of shattered lives, and we have a limited number of tools with which to fulfill our duty, to mediate between what is given and what is desired. And we recognize, as we always have, those of us who work in and around courts, that we can't provide solutions. We can only provide outcomes in particular proceedings. So we need to see ourselves as a part of a larger movement for human rights. And more specifically, I want to make some suggestions that we can learn from the advocacy model in capital cases. in which we are not simply arguing in every capital case that the state should not use its power in a certain way. We are arguing in every case that the state does not possess the legitimate power that it claims to have. Now, we look at the advocate's role in a capital case from the bottom up. We begin by looking at our client's conduct and character through all the possible lenses of refraction. The ABA standards tell us to go back 3 generations. We seek and obtain funds to hire mitigation experts and social scientists as mental health professionals. The Supreme Court has repeatedly held, most recently in Hinton versus Alabama, that in those cases, that's a constitutionally guaranteed part of the advocacy function, to have those funds. And we need this investigation and those resources because we cannot help the trier of fact understand things that we have not troubled ourselves to understand. And our client, after all, is someone else's child. You know, my oldest child is now 56 years old. I don't understand him half the time, and he's mine. So, and we have to remember in this process that it's about the clients and it's not about us. I wrote in a play a few years ago that we lawyers often imagine that we stand at the center of all the events by which the world is moved. That's what our lawyer ego tells us. Maybe, but after all, we stand where we stand when we stand only because somebody's in trouble and needs our help. It's about the clients. So from the bottom up, we exercise our right and our duty to present and obtain mitigation evidence. We insist, as the Supreme Court has expressly held, that that evidence must be given effect. That's the Lockett versus Ohio. This bottom-up work is effective. Every juror in a capital case cannot take the oath unless he or she says there are some circumstances under which they're willing to impose the death penalty. And yet, with good advocacy, we have sharply reduced the number of death verdicts all across the country, taking these cases one at a time and exploring the human condition of people we're to represent. Now, the more mind-bending approach here is the top-down approach that we use in every capital case. In every single case, we are pushing on against the number and scope of mitigating factors, the evidence we seek to produce. We challenge the state's right to impose a punishment and the means by which it seeks to impose punishment. We raise questions of procedural error and actual innocence, because in this field, as in capital cases, there are no ordinary cases. We are tempted by our caseload to emulate our adversaries and to regard this as just another case. But we do our work conscious that we are not only to use all our lawyer skills, but we're in the context of an international movement for change, the scope and definition of which the Supreme Court has recognized, for example, in Roper. After all, Roper was a case in which Justice Kennedy's development towards an understanding of the impact of youthful age in capital cases mattered. He got it wrong twice. I lost both those cases 5-4. And then when another lawyer came along who apparently knew what he was doing, we started to win some of those because of the process of educating the court about what it means to be a child. So in confronting the death penalty, we're not so much concerned all the time about the Eighth Amendment, but we certainly begin to think about the Fourth and the Fifth and the Sixth and the 14th. We remind the court in every case of the Convention on the Rights of the Child, even if the court is reluctant to apply it, because regardless of the signature, it has become part of customary international law. Because of state practice, it simply codifies certain things that are peremptory norms and therefore binding upon the courts of the United States. So, all I have to contribute is this observation again, that there are no ordinary cases. And I talked to Martine about this, and he talked about the need to get these lawyers up to speed on direct examination, cross-examination, and so on. Well, you've got my address. I go around the country and do these sorts of things. If you need a presentation about that, we can put one together in your town as well, because we're going to win these cases one kid at a time. Thank you.
Thank you, Michael. Casey Trippin with the Rights Foundation.
Thank you. turning on the mic. It does work. So I made a critical mistake. I now work for a foundation, the Rakes Foundation, which is funded by Microsoft money, which is why I'm using this, because I get a bonus every time I'm seen holding a Microsoft Surface. I did not know that the lights would glare off of it such that I couldn't read my notes. So we'll next version of the Surface, we'll have that fixed. I do not, for the most part, practice law anymore. I work for a foundation where I work on youth homelessness, and both nationally in Washington State and locally in King County. And my job in part was to help support efforts to stop the pipeline into youth homelessness from these systems that we're talking about here today, the juvenile justice system, the education system, the child welfare system. And so I think we're pretty close to having that all figured out. Next year we'll come back and celebrate. But I did practice for 16 years, working on a variety of different issues in Washington State, and see a lot of my former colleagues out here. I was lucky enough to be involved in some cases arguing the right to counsel, the constitutional right to counsel for children in foster care. And I'll quickly just talk about, I think, where we've come on that, because we've come a long ways in the last 20 years, but we've got a long ways to go. But I was thinking about this last night on the plane after my second whiskey, so bear with me, and felt like, as a parent, I had started to figure out why we were having so much difficulty winning the argument that children had a fundamental right to counsel. And I think there are two phenomena that explain this, phenomenons. One I will call the children of the corn phenomenon, which is is that like an old reference? Children of the Corn was a Stephen King. Okay, good, move on. Okay, this is the fundamental fear that adults have, that if children have power, they will ultimately turn on us. And be used against adults. And I have this fear every day raising 3 children, which is why I, as a parent, try to deny them as much power as possible. But I think this is played out a lot of times in arguing these cases before the court, that the children will make terrible decisions when they are given power, and attorneys represent that power. And somehow attorneys have incredible power that once you give an attorney to a child, they become this superhuman being who will destroy everybody. The second one, which is, I think, an interesting one, is this hate thyself phenomenon, which is that courts often don't see the value of lawyers. Which is and legislatures and others, they question whether lawyers actually have value in these cases. There's a fundamental distrust of lawyers by judges. And the thought that lawyers will behave irresponsibly or have nothing to do at all has driven this for many years. So I think the question today is, what if children had due process in a dependency case? I think it's instructive to look through that lens. And in the last 20 years, I think we figured out what lawyers are really supposed to do. What does due process look like? We have the 2011 ABA Model Act. Looking back, we might have given that a shorter name and more easy. But the issue of the constitutional right to counsel, I think, was well answered in the Kenny A.V. Purdue case. I see Ira is here, who played a big role somewhere. Raise your hand, Ira. Played a big role in that case. That is a very well-written opinion that answers, I think, all of these questions and deals with all of these phenomena. But yet, other courts seem to have these questions over and over again, the question that's been answered. In fact, a couple of weeks ago, Candelaria Murillo argued before the Washington State Supreme Court. Conde, where are you? There, for the third time before the Washington State Supreme Court, that children have a constitutional right to counsel in dependency cases. The third time, still hasn't been answered. All of these arguments were made by the court that I'm about to go through, all of them very well answered by Candelaria. But they continue to be raised, these concerns, by states' counsel and sometimes by CASA, and less frequently by parents' counsel. What's going to happen if we give kids attorneys? Well, what's going to happen, they say, is that courts are going to grind to an absolute halt. That is the fear, that courts will completely stop because kids' lawyers are going to be throwing every single motion at the court, and they will grind this to a halt. It's been answered. This is actually contrary to the evidence we have. We have the Palm Beach County study, which indicates that the cases tend to be shortened when attorneys for kids are appointed. We have other cases, we have other examples of early intervention by attorneys for children that cases are, even in the beginning, in the 72-hour hearing, that kids are going home more frequently. This just is completely contrary to the evidence, but unfortunately the phenomena of children of the corn is taking over. The second idea that, I'm just gonna keep doing that because until I can say everybody's saying it. Kids will request piercings, and they will want to go to the family with the pony and the pool. How many of you, I know one of you, has had a client who lived in a foster home with a pony and a pool? Raise your hand. Yeah, three. So I have two. A client who lived in a foster home who had a horse and a pool. And what did that client want? That client wanted to go home to her parent. That is just contrary to the evidence that all of a sudden you give kids something, and that will replace the love that they have for their families, and they'll make irrational decisions. I won't talk about piercings, but I think courts have forgotten that lawyers don't have to make every motion that our client asks us to make. If they ask for soda in the drinking fountain, we actually don't have to go into court and ask for that. The families will be torn asunder. Well, I think I just gave an example of that's not the case when we have good representation of children that's guided by standards. We had in Washington State, there's a circuit called the Hell's Canyon Circuit. It's comprised of the 3 southeast counties of Washington State, and most of which is stuck in kind of the late 19th century. It is exactly like it sounds like. It's kind of cowboy town. And the judge who rode the circuit, his name was Bill Acey. And I mean, literally, it sounds like something out of Westworld. All these, I'm really with it. All these references. I watch HBO. And anyway, Judge Acey got it in his mind that every kid in Hell's County Circuit in those 3 counties should have an attorney. I think it was about 140 kids. So they were being represented from the get-go until their case reached its final result. Well, he had the highest reunification rate in the state, and he was meeting all of the timeliness standards of the court. That, unfortunately, that practice went away when the county councils got together and decided it was costing way too much money, and again, were overtaken by one of those phenomena. Lawyers won't know what to do. We hear this all the time. What's a lawyer gonna do? They're not gonna know what to do. We have 5 model acts and 5 standards, a red book. We have tons of guidance about what lawyers are supposed to do. But no matter how many times we say this to a court, they just don't seem to get it, that actually lawyers do a lot for children in dependencies. They're guided by a lot of structure. It is amazing that still gets asked. We even have, as mentioned earlier by Frank Ortoni, the QIC study, this national study, which, if I could boil it down to one sentence, rested upon the theory that better lawyering produces better outcomes. That was the idea. Answer: true. Better lawyering produces better outcomes. Well, another one, it will cost goo gobs of money to do this. Again, the evidence is in, and it indicates that it's likely to the contrary. Yes, lawyers have to be paid most times, but in fact, good lawyering produces better outcomes, shortens cases, saves money. That is where the evidence is heading, and we now have good evidence about that from Palm Beach County and others. This really is the opposite of true, or as I like to call it, untrue. And finally, lawyers, I'm channeling one of our great leaders and coming up with new words like untrue. Lawyers will be wasted on little kids. Courts are so stuck on this that, oh yeah, we get what a lawyer might do for an adolescent who can talk about what they want and make some rational decisions. But what are they going to do for a 4-year-old or a 5-year-old? They're not going to be able to do anything. And again, to this, I think the evidence is in Palm Beach County. That was representation of younger kids.
and the outcomes were quite good. That lawyering, good lawyering for younger kids who have rights actually results in good outcomes. Let me just quickly turn and finish, because I'm also supposed to cover youth homelessness, and I'll do that very quickly. This concept of overdue process, that we've missed opportunities to provide due process to young people, and what the result is, and as was referred to in the first session, often is terrible outcomes. One of those is youth homelessness. That when we miss the opportunity to do good lawyering in juvenile justice cases, in child welfare cases, in education cases, we are setting up our clients for terrible outcomes in the long term. And the link between child welfare and homelessness is strong, but I would argue misunderstood. We have focused a lot on youth who age out of foster care because the link is strong between aging out of foster care and homelessness. But it's not by far the only link. We are seeing young people who go back home, whose families are left without support, who are adopted and the adoption is disrupted. That, in fact, in one study, is the #1 indicator that a young person is going to end up homeless, is that their adoption is disrupted. And we've left them without anything to do. And then young people who didn't get into foster care. We've seen some amazing lawyering by Bay Area Legal Aid and others that helps young people get the support that they're entitled to, that have been out being trafficked and yet should be getting services from the state. Young people who've been separated from their families through unnecessary detention, which ultimately leads to nobody being capable or willing to pick them up from that detention center. Their families have been left without support, and that leads to the homelessness. Young people saddled with debt. Young people who've done everything they can to get back on their feet after something going wrong. And the one thing that stands between them and housing and employment is the fact that they've got tons of debt that nobody ever thought they really could pay, that was saddled upon them by the courts. And finally, young people excluded from housing or employment by being put on registries for sex offenses or drug offenses or violent offenses. I think we struggled what to do about this. Even in the Model Act, we talked about whose job is it to work on collateral issues. Public defenders already have enough work, and sometimes they're just frankly not allowed to do this. What we came to the conclusion is somebody has to be doing it, and I think that's where we're headed in the next 10, 15, 20 years. I think organizations and efforts like Lawyers Fostering Independence that works on those collateral issues, we have to be there, and we have to not just wait for those cases to come to us, but we have to be willing to be lawyers who go to the young people who need it.
Thank you, Casey. Bob Listenby could not be with us, but to our benefit and fortune, we have Sue Vivian Mangold with the Juvenile Law Center.
Right, thanks. Yeah, we in Philadelphia are doing a lot of Bob Listenby can't do this anymore, so we're filling in. But it's also a really exciting time in Philadelphia with our new DA and with Bob Listenby as his first DA. So keep your eye on, for lots of reasons, keep your eye on Philadelphia. I'm going to use just a few minutes of my precious 5 minutes to talk just a little bit more about the case of Mary Ellen, because I think it's a worthwhile question to ask, what if Mary Ellen had an attorney? So Mary Ellen was actually the illegitimate child of the Wilsons. Mr. Wilson died, and Mrs. Wilson continued to raise Mary Ellen. And she remarried Frank Connolly, so Mary and Frank Connolly were raising Mary Ellen. And a woman named Etta Angel Wheeler, who was like a professional do-gooder, was visiting a dying woman from her parish and asked the woman, is there anything I can do for you, as you prepare to return to your creator? And the woman said, do something about the cries of that child I hear in the night. And so this woman, Etta Angel Wheeler, who happened to be the wife of the editor of the New York Times. And so the story of the case of Mary Ellen is documented day to day in the front page of the New York Times. Mrs. Etta Angel Wheeler finally finds the tenement house where Mary Ellen lives, goes to the home, and she describes a drunken man, who's Mr. Connolly, who slams the door in her face. She returns a second time, same thing happens. The third time she comes, Mr. Connolly's not there. Mrs. Connolly lets her in and says, help me help Mary Ellen. And ultimately, Etta Angel Wheeler, through her sort of society connections, as Tony said, connects with Eldridge Perry, who's counsel for the Society of the Prevention of Cruelty to Animals. And an organization starts, that's the Society for Prevention of Cruelty to Animals and Children. And that society removes Mary Ellen, and she ultimately grows up, removes her from New York City. She ultimately grows up in Rochester. Mrs. Connolly, the woman who was caring for the illegitimate child of her first husband, is arrested and prosecuted for the offenses, although all the evidence at the time is that the abuse was perpetrated by her second husband, Mr. Connolly. We don't know what Mary Ellen would have wanted because no one asked. But just imagine if in 1874, instead of founding the Society for the Prevention of Cruelty to Animals and Children, services had been brought to protect the relationship between the woman who had cared for Mary Ellen since she was a child and Mary Ellen. Now, maybe that's completely unreasonable. Maybe that wasn't what either of them wanted, but we simply don't know because Mary Ellen didn't have an attorney, and we don't know what it is that Mary Ellen wanted and what would have been possible, and not only what the trajectory of her life might have been, but what the trajectory of our whole field might have been. So I think it's always interesting to just kind of critically look at history and think about how might lawyers have intervened and asked different questions and perhaps brought about quite different results. But one of the reasons I was asked to join this august panel was to talk about other areas of gaps and needs in terms of child representation, especially in the juvenile justice system, but I'm going to talk a little bit about the child welfare system as well. As you know, Juvenile Law Center no longer does direct representation cases. Back when it was started in 1975, that's exactly what Bob and Marcia and the other founders did. But we've sort of evolved through time, and now we do impact litigation. And so some of our work is class action work, but most of the 50 cases we have at any given time are appellate work. And it's through those appeals that we try and work with counsel who was originally handling the case to raise new issues, and it's in those new issues that we often see some of the gaps in representation and in the gaps in arguments before the court. A few years ago, Juvenile Law Center worked with many of you with funding from Robert Wood Johnson to put together a publication on trauma and resilience, and it was really an attempt to bring representation of children into the field of trauma-informed care. But in producing the publication on trauma-informed advocacy, of course, we all recognize that we should conduct our own practices and our own interactions with kids in such a way that we're not re-traumatizing, and that we need to think about the secondary trauma to us and our staff. I called them our family, but welcome to Juvenile Law Center. But us and our staff. But what we also found doing a survey of cases where trauma had been raised across the country is that trauma history is often used against kids and against their parents. And so trauma-informed service is one thing, trauma-informed advocacy is another, and needs to take into consideration the categories of cases, such as when kids are at risk of being tried as adults, when the question is whether kids should be placed in congregate care or closer to home, whether or not parental rights should be terminated. In those instances, it seems that kids' trauma history is more likely to be used against them for a more harsh outcome than as a mitigating circumstance. And so the importance of knowledgeable advocacy who can decide, can work with the child to decide when mental health records should be introduced, that these screenings and assessments should not just be sort of part of the court record. Those are mental health documents, and how are they going to be used, and what are the rights of the client? And As you know, Juvenile Law Center and many of us around this room have been involved for decades around bringing the developmental science into our court litigation and into our policy making. And for many years, Juvenile Law Center participated on MacArthur's research network, and the Academy of Medicine is just convening a new committee to look at adolescent brain science and its implications, and I'm privileged to be part of that committee. But sad to say, I'm the only advocate so far. I'm pushing, but I'm the only advocate that's on that committee. I have all the respect in the world for the neuroscientists and behavioral scientists who are on the committee with me, but the whole point is, and its implications. And so we need the voice. I'll be pushing out as much as I'm allowed to try and kind of build that piece of the information. But many of us have been working for decades to bring the adolescent brain science, both neuroscience and behavioral science, into the courtrooms. And while we've been, have celebrated great success at the deepest end of the system, looking at eliminating the death penalty, life without parole, and mandatory life without parole for kids, and in the JDB case on how kids conceive of being in custody for Miranda warnings, we haven't been as successful, and this is where we're pushing on issues around trying kids as adults, keeping kids in foster care longer, eliminating abusive practices such as solitary and strip searches and use of physical restraints. All of these are, have space for arguments for the adolescent brain science to push the practices that we're now doing, but that's still on the horizon. We're still making those arguments, sometimes successful, sometimes not. We've all long been working on issues of crossover youth, but we're seeing more and more kids crossing over, not because of criminal activity or delinquency activity that they get involved in while they're in the foster care system, but instead because of predictable adolescent behavior while they're in especially congregate care in the child welfare system. So kids, shove another kid, punch their hand through a door, and they wind up going from congregate care or group home in the child welfare system into the juvenile justice system. And again, sometimes that gap in representation, sometimes that inconsistency in representation, when kids are making that move, and then their inability to get back into the child welfare system. At the far end of cases, if you will, in the life of cases, the strong need for attorneys. Casey mentioned the crippling debt that kids exit the juvenile justice system with. And often at that moment in time, their public defenders or whoever's been representing them in the juvenile justice system is long since gone. These kids have been on probation for years, sometimes charged $1 a day for probation, which sounds like nothing, but it means they leave the system with a $700,000 debt for 2 or 3 years in probation. And someone needs to be making arguments to release that debt now that they've been successful in whatever crazy set of, complicated circumstances they've been told they have to fulfill in probation. Even when they're at that point, they're leaving the system with crippling debt. The terms of probation themselves, they keep getting added onto for the least infraction. But again, many times when that happens, public defenders have long since exited the scene, and these aren't coming into court hearings. This is sort of part of the way the court does, the way the system does business, but at the far end of cases. Kids exiting the foster care system with a right to re-entry up to age 21, wanting to re-enter and being denied re-entry. Where do they get counsel? No, they're not getting into the door. So we've been successful in arguing cases where kids were arrested and then wanted to re-enter care, and in several cases where kids left care to go to out-of-state universities, and so they were told they could no longer be served in the foster care system in their state, and now they want to re-enter care. They're eligible, they're following all the rules, they're below age 21, but who represents them at this point? They're not in the system anymore. And so again, these sort of gaps in the system where representation is so important. We all know about the great need for more appellate work in the child welfare system and attorneys to be able to do that work. And the last thing I wanted to mention was, I think within our community, we're beginning to embark on a real debate about waiver. We at Juvenile Law Center feel strongly that the adolescent brain science isn't black and white. It's more sophisticated than that, and there's a context in which decisions are made. So it's not the case that if we say kids aren't necessarily prepared to make a decision in one situation, then we're giving away the ranch, that then they're not going to be able to be given been thought to have the ability to make the decisions in other situations. And we've been really influenced by our experience in the Kids for Cash scandal, where thousands of kids waived counsel in a courtroom where there was a public defender, and they were being asked about waiving counsel, and they all waived counsel and proceeded through that horror story without representation. So we feel strongly that the right to counsel is not something that kids should waive, and I know that's a debate that maybe we'll have more time to talk about later, but I just wanted to toss it out there when we have such a wonderful assembly of people to discuss these issues.
Thank you, Sue. So with that great introduction, what issue is raised? We're going to talk to you about what if kids had an effective right to counsel in all proceedings that affected their basic right? Would it ensure a fair treatment through the normal judicial process, through the system? If citizens were looked upon as being children, or children were considered citizens? This is part of what we're going to talk about on today, and our speakers are going to talk in greater depth. Please note that the bios for all of the speakers are online if you would like to read a little bit more about each of our speakers. So Martine, you talked about the difficult climate in which lawyers for immigrant children are currently operating. What changes are lawyers making to adapt to this new reality?
Thank you, Francesca. Yeah, so I talked a lot about some of the bad things that are going on. There's a few more before I'll talk about quickly how we're trying to rise to the challenge. So immigration judges are not independent judges. They are employees of the Department of Justice. So an immigration judge's boss is Jeff Sessions. So just recently, Attorney General Sessions released an evaluation system whereby immigration judges have case completion quotas, and their job security or their job advancement is going to be impacted on how many cases they are able to close per year. That's obviously problematic for so many reasons. Whether a judge can be an impartial arbiter when they're thinking about their job security obviously raises a lot of concerns. And also, there's this weird phenomenon in immigration law where the Attorney General can refer cases to himself or herself in the past. So the Attorney General has grabbed hold of this power and has referred several cases to himself over the last few months that when he issues a decision could drastically alter the way cases are litigated in immigration court. So for example, for children, this is very important because they may have their immigration court case, but if they're seeking relief, meaning they're seeking a defense to their deportation, they have to go to another arbiter, which is the Immigration Service, USCIS, to adjudicate, for example, an asylum claim or a claim for a special immigrant juvenile visa, which is for abused, abandoned, or neglected children. So that's a collateral matter outside the four corners of the immigration court hearing. And the way it works now is attorneys are able to get cases sometimes administratively closed in the immigration court side, giving them time to go outside the court to seek that relief. And there's a decision coming down from the Sessions whether immigration judges should even have the power to close those cases so people can seek relief in a collateral matter outside of court. So it's potential that children will no longer be able to even seek those forms of relief outside of court if that comes down with a bad decision. And there's also the question whether they can even get continuances to do that. So if you can't get administrative closure, a lot of times attorneys get lengthy continuances to pursue those claims outside of court. We're expecting Attorney General Sessions to weigh on whether it's even appropriate for a judge to grant a continuance to do that. So if a kid can't get a continuance, they can't get administrative closure, how are they even going to seek these forms of relief? So, so I mentioned also there's funding for immigration lawyers for children, more than there's ever been. There's still not enough. I mentioned that it's about 0% chance likely for a kid to win a case in court without an attorney. It's been shown children are about 5 times more likely to win their case if they have an attorney. Now, if we're going to keep that ratio as it is, or even elevate that ratio, we need to create good attorneys who provide quality representation. And in this changing landscape for immigrant children, it's getting more difficult, but we have to rise to the challenge. So what are lawyers having to do these days? Well, they're having to fight every little fight. So it's been kind of tradition, I don't want to say tradition, but it's been common for immigration lawyers with programs with limited resources to pick their battles. So for example, if you have a kid that you think you can get asylum for, you may not fight every single little detail in immigration court. So for example, the first step in an immigration case is you have to plead to the charges on the notice to appear, which is the charging document. Now, it used to be that we would concede the charges, essentially saying, yes, child is from Mexico, not from the United States, is not a citizen. Yes, child did not enter with a visa. And yes, we concede that the child is removable, that's a fancy word for deportable, from the United States. And then we would focus all our efforts on getting the asylum claim, on winning the asylum claim. So now we have to train lawyers to fight every little detail, to not concede the charges, to make the government prove every single little element of their case, and make them do their work and put a cog in the wheel and make things more difficult. We have to train lawyers to file more motions to terminate for obscure defects in the government's case. For example, were documents served properly on the child? Were their rights explained to them the way they should have been at the border when they were arrested? There's all kinds of regulations about this, and you can make challenges in court that could potentially get a case thrown out of immigration court if the government didn't file these things correctly. We need to train lawyers to do that. We need to be better appellate lawyers in immigration. So as more cases are being denied, we need to train lawyers to write more and better appeals. We need to craft better orders in state court. So I mentioned special immigrant juvenile status earlier. It's this weird form of relief that requires you to go into state court, get a state court judge to declare that the child was abused, abandoned, or neglected, and then you use that as the golden ticket to apply for a visa. Well, the government is making it harder and harder to get those visas because they're scrutinizing the state court orders and they're interpreting them differently, and so we have to write better orders and we have to adapt to that. And really, we have to work together as a community, as a united front, to make sure we're all doing this so that it's not just attorneys in one part of the country making these technical challenges and others in other parts of the country not doing that. And I think we have to continue to work to better understand our clients. Mike mentioned earlier, and I took this to heart, it's not about us, it's about the clients. And our clients are coming from a very different part of the world than we are from. Many of our clients in the immigration area are from Guatemala, where they're indigenous language speakers. They come from a very different part of the world. They don't even speak Spanish sometimes. They don't speak English. They speak one of 40+ indigenous languages. We have to work to better understand them and make sure that we are representing them in a way that makes sense, given their culture, their language, and the trauma that they've suffered in their home country and on their way to the United States. So that's what we're doing. It's a long fight. I think we're up for it. We have lots of partners out there. We need more. We need more attorneys, and we need to train them up to be even better. And maybe I'll take you up, Mike, on one of those presentations on trial advocacy, because that's another area where we need to move things along. Okay, so we're going to move this along. And is this, Kathy, where we're supposed to get some audience participation, right? Do we need to put every poll information up?
Sure. Okay. The question is, what should you be doing to be an effective child's lawyer?
And just so everybody knows, I'm sorry, that if you want to respond on your computer, the website is there, pollev.com. If you want to respond on your phone, you text the Kathy Krebs 1
Great. So while we're waiting for some folks to type in some responses, I'll throw it out to the panel for anyone who wants to weigh in. So what should we be doing to be an effective child's lawyer?
There's a cartoon of Honor Daumier of an impoverished man standing before the French judge being charged with stealing food. And the judge is saying, "You were hungry? You were hungry? I myself am hungry 3 times a day. I don't steal for that." The point is that we confront mythologies in representing our clients, and we are in the grip of some of them as we look at our own clients and fail to understand them. That's the first thing. Think, for example, of the battered spouse problem, how for so many years we wrestled with the fact that when the battered spouse finally one night, in the narrowly defined heat of passion, interrupted only as she reloaded, bugled her abuser to Jesus. Well, it was a long time before homicide law began to take account of that family situation and in which you could talk about it with judges. So that's the most important thing that we can do, is to understand the mythologies that drive the system we are confronting. Look back at historical examples. How long did the separate but equal myth survive until it was exploded? And the mythologies that we ourselves grew up with that might obscure our understanding of what our clients are about.
I was just noticing that there seems to be a theme emerging among what people are saying about being an effective child's lawyer. I guess I would say one other thing other than listening to our client, or in addition to listening to our clients, which is absolutely critical, is the need to challenge the system and to pick our heads up and look for the patterns of the injustices that we're seeing, and not just agree that the system is what it is and we can't do anything about it. I think those who do systemic litigation and those who do legislative advocacy are always looking for those examples, those stories, those cases, those themes that can be turned into a way to change the system. And you know, those of us who've done it, it's often hard at the moment you need that story. You need that example to find it and find the compelling story. And so the connection between those who are doing the work at the ground level, who are representing young people, and the young people themselves, and those who are doing the systemic work, there needs to be a tight partnership. And those public defenders and attorneys in immigration court, or attorneys in dependency court, or in juvenile offender court need to be at the ready to support the efforts to change the system. So listen to your clients, but don't forget what they have to say, and don't forget how to connect that story to the change in the system that needs to take place.
Our youth advocates have 3 pieces of advice. You know, prepare your clients well so they can have a meaningful conversation with you. Advocate for what they say and give them an opportunity during the hearing to say, you know, is there anything else that I missed, or how's this going? Anything we should be doing differently, and make sure they're there at court, which means scheduling things around their schedules. When we all pull our calendars out to see sort of when we can make the next court date, if your client has a day off of school or a day that they're dismissed early, use those times, but schedule around the child's schedule so that they can be present with you in court. Those are the 3 recommendations from our Youth Advocates program.
Thank you. And audience, great responses, overwhelming input with regards to listening to your client, challenging the status quo, don't take no for an answer. Those are powerful responses and on point, in addition to what has been provided by the panelists. Thank you. So let's talk about the role of lawyers in perpetuating bias or promoting equity. It is said that due process balances the power of law of the land and protects the individual, and in the case of whom we're speaking of, children, from it. So what is the effect of having true due process on equity rather than furthering historical discrimination? Casey?
Well, I certainly in no way profess any expertise, but I think back on my career, as a white male attorney advocating mostly for young people who are not. And I think some reflection on some hubris about thinking that just because I was lawyering that I didn't need to be thinking about the role of implicit bias that I was foisting both onto the client and onto the case. I think we are doing much better as a field about making sure that the lawyers and those in court confront both the fact that these systems were created in large part to perpetuate the inequities that already existed and have done a very effective job, whether it's child welfare, juvenile justice, or the school system, that they were created to maintain the status quo and the power structure along race lines and now other lines as well. So I think we need to dive much deeper as lawyers into understanding our own inherent bias, understanding the historical discrimination that's built into the system. And we need to be, as much as possible, guided by structure, by rules, by training that limits, I think, what is a very dangerous concept of best interests. I think, not saying that we have a better concept necessarily than best interests, but best interests by itself, as determined by those in power, means judgment of certainly judgment by a white power structure, often of families of color in a way that will only make things worse. So three things. One, I think we need to work with others to uncover where the system is resulting in those most disparate outcomes. Folks on the ground are seeing that, but too often they're not talking to others about where those disparate outcomes are happening. Two, as I mentioned, let's make sure that we're guided by standards and laws that constrain the inherent biases. Three, as I mentioned, change the system. We absolutely have to change the system. We can't agree that the system as it is going to work well, or to quote the great Frank Servone, we need to make sure that those crazy ass ideas become law. And fourth, I think we need to step back and create space for people like Sixto Counsel to step forward and actually lead the effort. I think there's too much of us white male lawyers leading the charge, and that's not going to change the system. We have to take a step back, create space, make sure that there is space for those who've long been affected by the system to lead the charge to dismantle and change it.
Could I make a suggestion? Would everybody grab your phone and put up what's the most imaginative motion or gutsiest thing that you ever did in a court? Can we tweet? Is that okay if I ask people to tweet that? Oh, she was going to go to the next one. Oh, did I get ahead of your time?
You're fine.
Okay, well, I'll start. I was trying a general court-martial, and those are very frustrating. You talk about a juvenile justice proceeding, and my wife tried to pull me back and make me sit down. She's my co-counsel. And I looked at the judge and said, "Excuse me, Your Honor, do you have a copy of the Constitution up there?" And she said, "Well, yes, I do." I said, "Well, why don't you just throw it in the wastebasket? It doesn't appear to be doing you any good." So anyway, I started. You go ahead.
I think you can use every poll, but I think we're also willing to, if people want to raise their hand and shout something out, especially if it's embarrassing to you. While we're waiting on that, this is not a motion I made, but I was in court arguing on yet another constitutional right to counsel and dependency case, and our client had retained us, and the question was, could our client have retained us? Court of Appeals, and that was the preliminary issue before the Court of Appeals. I had I was all set up. I was making the argument. I was up there at counsel table. The pews were behind us, and I made my argument. I was killing it, and the court ruled against me. I guess I wasn't really killing it, but the court said, "Nope, client, the child cannot retain you." And there was just, and I know some of you were there. There was just kind of a moment of silence, and I was like, "Okay." So I had nothing to do, so I went back to counsel table and I picked up my trial notebook or my appellate notebook, and I just walked and sat sheepishly in the pews and watched the rest of the proceeding go. So it wasn't an imaginative motion, it wasn't a successful motion, but it was one of those odd moments in the journey to children's right to counsel, where all of a sudden, one second I'm in the case as counsel, the next second I'm just watching it from the pews.
So I don't know if this is a specific motion, but I had the task of getting immigration relief for children that did not appear sympathetic on the surface. For example, children who had been forced into work with criminal cartels in Mexico and forced to do really bad things. For example, weapons training, carrying drugs across the border, fighting with other gangs, even engaging in shootouts, and but these were child victims. They were forcibly recruited into these situations, and so our task was to humanize the child, make sure that the judge saw them as a child first, as a victim first, despite the stuff that they had done. And then another thing that I did was to try to incorporate best interests into an immigration judge's decision. I know Casey just talked about whether that's the best standard, but in immigration court, it's better than nothing, because there is no best interest determination to be made by the immigration judge. But if you can convince a judge to take it into account and making a decision, you've gone a long way into helping out your client. So now there is actually a provision in federal law for best interest determinations to be at least presented to the immigration judge. But before that was available, I worked on a couple cases to bring some of those considerations before an immigration judge.
Thank you, Martine.
I feel like this is one of these moments where, like, I'm not Bob Listenby and I'm really not Bob Schwartz. And if Bob was up here, he would have like some fabulous story to share. But I'll just share one. When I was a staff attorney at Juvenile Law Center, and I was pregnant, and the judge, I was representing a group, a family of children, and it was a petition to change the goal of the case from reunification to adoption. And the mother came into court, and she was pregnant and clearly high. And the judge, was scheduling the hearing and set a date. And I said, well, I need the date to be sooner because I'll be going out on maternity leave. And he said, when's your due date? And I said, July 11th. And the mother in the case said, oh, that's the same as my due date. And the courtroom just went silent. We weren't thinking of her really as a person with any kinds of rights or needs or challenges. And at that moment, I vomited all over the floor of the court. And so then we got a continuance. And
Quite an
and
imaginative
Bob said,
motion.
great job, I've never done that.
Creative lawyering.
Very good. And the audience is coming through once again with very profound input in terms of imaginative motions. One that really stands out is the student who filed the motion to not be treated as the black kid from the south side of Chicago. Others, including contempt motions for failure on the part of the agency, motions to delete records for unsubstantiated claims against the child. Certainly we probably have all seen those, right?
I want to know the end of that sentence about the iguana. From...
Wow. Good.
Can I own
So-
one of my own
Sure.
biases that was caught there? And thank you. I didn't mean to, but I think in speaking I may have sent the message that white men were the leaders, had been the leaders of this effort. I do not mean that. Obviously white women also, but I think white women need to step back too and own their biases. So all of us are steeped in it. But I do realize that there have been some amazing women leaders. I'm now in my second job where I'm the only man, and where we're doing children's work. So yes, to the extent that I sent the message that white women hadn't done incredible, or women hadn't done incredible work in this area. True, and to the extent I sent the message that white women didn't need to be steeped in how their inherent biases are affecting the system, also true.
Thank you, Casey. This is such an important area, and of course, so much great information to provide. But we are going to propel forward. And Mike, let's talk about how to understand your client in the context of human rights. You made a mention about tossing the Constitution in the garbage can before the judge. And the idea of those principles, of course, are designed to protect the rights of an individual from unfair treatment from children. So what is the role of the lawyer in terms of clients as human rights?
You can find on the monthlyreview.org website a talk I gave at the University of Texas about Roper versus Simmons years ago. But, today the focus of human rights has changed. In the 19th century, international law was the big powers made it. But in the wake of the Nuremberg judgment, individuals are the bearers of human rights. The next thing to know is that international law is a part of the law of the United States. There are some justices that haven't believed that, but that's been the case ever since 1900, the case called Paguete Havana. So we have the right and obligation as lawyers in court to look to the movement for international human rights, specifically the Convention on the Rights of the Child, but also the peremptory norms that have developed from state practice and the opinion of judges, and to familiarize ourselves with that. Bernadine teaches a course, maybe she's not going to do it anymore, so you'll have to look the old Cliff Notes, in the Netherlands every year about the international law aspects. People are writing about it. That's what I'm talking about, that we have to educate judges and deciders of all kinds to the importance of applying these principles. And we might not get any traction until, down the road somewhere, but we've all got to be part of the conversation, and to find new ways to look at things. I'm going to give a shout out. My son decided the detention case of Florecel Ramos, the woman who was picked up and taken away from her children. The Immigration Service told him he didn't have the right to do it. He said, yes, it's called habeas corpus. We got that right no matter what. As an example of another imaginative look, that's the United States District Court for the Northern District of California. So there you go. Oh, I wrote an article in a thing called Human Rights Brief, which you can look up. It's a publication on the relevance of, who we representing the other in the context of international law.
So we're going to ask the audience, knowing what you know now, what is the one thing you wish you knew as a young lawyer?
Is this working? Okay. So while we're waiting for some responses to come in, I wish I knew that the first time I stepped into a courtroom was really maybe my only chance to earn some respect from a judge and from opposing counsel. Because, as Casey mentioned earlier, a lot of times they make that assumption that we're not there for any particular help or purpose from their point of view. And I made the mistake as a young lawyer a couple times of not realizing that, and infected my relationship with opposing counsel and judges going forward. So, what I tell young lawyers going into court for the first time now is that you really have this one shot to go in there, prepared as you can be, guns blazing, professional, competent, and so that you set that tone going forward, especially if you're going back to the same judge and courtroom, all the time or over and over again. So that's one thing I wish I would have known.
Claude Monet painted the facade of the Rouen Cathedral 16 times. And each impression is a different impression of exactly the same facade, of exactly the same procedure. It's actually the same court, or church. I'm a little confused. I'm suggesting that in every case we need to have an impression of the case, carefully built up, but nonetheless an impression of the whole case. And every single time we rise to our feet, every document we write, even if it's a letter, must encapsulate, must have in mind our impression of the whole case. We have to say our case every single time that we stand up. There is no such thing as a trivial opportunity to address the folks that are going to decide our cases. The risk of wasting time. Toward the latter end of his career, I used to have lunch with Justice Brennan from time to time in his chambers. And one time I walked in, he said, "Excuse me, I'm just talking to my granddaughter. You know, she's at war with her parents. I really don't understand why. So she calls me and I send her money from time to time." Well, which reminded me that, you know, they're humans. They carry around a set of attitudes, and our every opportunity to confront them and to talk to them has to be in the context of a view of our whole case.
Okay, I'm going to ask Sue if you could chime in on telling us how the Juvenile Law Center learned and shared about trauma-informed advocacy.
I think given how little time, because I saw Angela's sign go up, I think I talked about that sufficiently in my remarks, and I'm happy to talk to anyone who wants to learn more about it. But I'd mostly be interested to hear how your efforts at advocating around the trauma histories of your clients aren't being affected in court. So I'll be around all day, and I'd love to hear more.
Thank you, Sue. We have one last question for the audience, and that is, should youth have the right to waive counsel? Okay. Well, we're going to delete that one. Imagine it was never there. We'd like to thank the panelists for the profound input that was provided on today, and thank you for your input and your responses. Very much appreciated.